So let's go back to March 2017. And that was an historic time in the field of education and specifically special education for families and for students, because that's when we had a unanimous decision from the Supreme Court in the Endrew F versus Douglas County School District. And it was amazing to see that parents actually can prevail, and to have parents prevail at the United States Supreme Court level was very exciting. And like I said, a historic moment. So we are lucky today because we have the attorney, Mr. Jack Robinson, who represented Endrew F. and his parents in that case. And so we're going to talk a little bit about that case, but then also look at how things apply to now in this kind of COVID-19 schooling at home circumstance, right? So what we want to do is we want to encourage you to ask your questions. If you are new to the show, I'm Charmaine Tanner. I'm a retired teacher, parent, and host of this weekly show. And I do advocacy full-time for families. So I want to bring on our guest, Mr. Jack Robinson, and he resides in Colorado, which is where I used to live for decades. And Jack, we appreciate you being here today. So thank you and welcome.
Sure. Glad to be here. Thank you for having me, Charmaine.
So I thought what we do is for people that maybe, weren't, that knowledgeable about what actually came out of the Endrew F case, if you could kind of summarize that, and I think that would be a good starting point for us.
Sure. So not to go too far back, but, just generally, as most people know, the IDEA has two fundamental requirements. One is the requirement of providing a free, appropriate public education to students with disabilities, and that free, appropriate public education has to be in the least restrictive environment. So those are the two sort of overarching requirements of this very sort of detailed civil rights statute. So anyway, free appropriate public education. So that is what's required by a school district to provide for a child with a disability. What was in flux for, 35 plus years since the IDEA was enacted was, what is an appropriate education? What's an appropriate public education? Free is, that's easy to understand. Education can be a slippery slope as to what is education, academics, behavioral functioning, that type of thing. But, what is an appropriate education? What is a school district required to provide a student to satisfy the requirements and the purposes of the IDEA? And so we had a U.S. Supreme Court case back in 1982, it was decided. The IDEA was enacted, in essence, in 1975. The Supreme Court case, Rowley, was decided in 1982. And it did hold, that the IDEA requires a substantive right to a free, appropriate public education. But what the case did not do, which became a matter of controversy, is what, if there's a right to it, what is that right? What's the educational benefit that a school district is required to impart on a child with a disability? So anyway, circuit courts, courts out there since that period of time divided up into different camps as to what an appropriate education is. How is a judge or how is an IEP team supposed to determine the adequacy of this IEP? What standard do we use? And they came up with two different standards, one being a some educational benefit standard and the other being a meaningful educational benefit standard. And really, as it came down, different states or different regions of the country had really radically different ways of determining whether a school district was fulfilling its obligation or not. And so a case of mine, actually back in the early 2000s, Luke P. or Thompson School District versus Luke P., sort of squarely addressed that issue of what is a free appropriate public education. When do we know when a school district is doing its job or not? And in that case, that was decided by the 10th Circuit in 2008, decided that an appropriate education is one where the child was receiving merely more than de minimis benefit, basically a little more than nothing. That if the school district could show that the child was making some progress on some goal included in his IEP, regardless of deteriorating behaviors or regardless of regression on other skills, as long as the school district could show that the child was making some progress in some IEP goal, that was sufficient. And so, so that was the standard, merely more than de minimis benefit. And, I was quite devastated by that decision, feeling responsible for that, but knowing that, it would be virtually impossible, not impossible, but very difficult for parents to challenge the adequacy of an IEP under such a low bar. And so anyway, a few years later, this Endrew F case comes along, which I felt like I never thought it was going to go to the U.S. Supreme Court, but I did think that here's a case where the IEP goals and objectives are basically sort of regurgitated year after year. We have a situation where his behaviors were deteriorating. There's an acknowledgement by the school that they couldn't address his behaviors. They didn't attempt to do a functional behavioral assessment or a behavior intervention plan. And so I thought, all right, there's no evidence of progress. We have behavioral deterioration. Certainly, this is not even going to live to or rise to the level of this some educational benefit or merely more than de minimis benefit. So long way of saying, so anyway, we of course lost ALJ stage. We appealed to the U.S. District Court, lost there, and appealed to the 10th Circuit. We lost there. And all along the way, the courts or at least were saying, yeah, boy, this is a close case. Yeah, there's not much evidence of any progress here, but the bar is so low that, and we do find some evidence of some progress. Of course, he's getting older, right? I mean, if you drill something for a year, of course, you're going to be able to string more beads at the end of the year than you can at the beginning. So anyway, we petitioned writ of certiorari to the U.S. Supreme Court to determine, all right, here it's been 30 some odd years since the IDEA was enacted. It's been amended twice since then. We're in a whole new age. Surely, children with disabilities are entitled to more educational benefit than merely more than de minimis. And Supreme Court, it's time for you to, address head on, what does that mean? The chances of having the U.S. Supreme Court take any case, let alone a special education case, is slim to none, less than 1%. And they took this case, and they thought the fact pattern for this case was, a good case to establish finally establish a standard for a free appropriate public education. And that's what they did, as you said, in March 22nd, 2017. They issued a decision saying that rejecting, that was our main goal in this, was to have rejected that merely more than de minimis standard, which the Supreme Court did very, very soundly, saying this merely more than de minimis standard doesn't provide an education to a child with a disability at all. And their words were, it's like sitting them in the corner, waiting for them to drop out or graduate. So merely more than de minimis standard was rejected, and they established what they said they called a markedly more demanding standard that a school district is required to develop an IEP that's reasonably calculated to enable a child to make progress appropriate in light of his or her sort of unique circumstances. And what that means is for children who have the ability to achieve a grade level, to advance from grade to grade, but do have learning disabilities or other disabilities, that it requires a plan that enables them to achieve to that potential, that they can master core standards and advance from grade to grade, just like every other child, just like every general education child. So in my estimation, that is equal opportunity, that you have to be able to educate these kids. And those are the vast majority of children on IEPs. And for that smaller population, sort of like Drew, who does not have, say, the ability to achieve at grade level, the IEP still needs to provide a FAPE, and that has challenging objectives, so that and I want to emphasize too here the notion that's in the Supreme Court case is that the IEP is not the sum and substance of a child's education, right? The IEP is a plan to enable that child through accommodations or modifications, but accommodations, special education and related services, to enable the child to access education with a capital E, such that most and a lot of school districts get sort of myopic, and especially we'll move on here in a second to this COVID-19 situation, but school districts do, and I think parents get lulled into this too, thinking that, all right, the IEP is the FAPE. IEP is the appropriate education. But most IEPs maybe only have, adaptive PE, or, IEP may only have, reading, literacy services or something like that. Surely that does not, the IEP still needs to ensure that a child is making appropriate progress in social studies and science and.
Yeah, and I think that's an excellent point. And I think I need to remind myself of that, because I think, like you said, so many times we look at this as, what we need to, be looking at for language and, making sure it's worded specifically and everything. But this is one slice of their education picture, right? And they do, the whole point is that they're going to have access to general ed curriculum. And so, yeah, I think that's an excellent point for us to remember. And I was going to say hi to some people here. Lisa, I'm sorry, is with us. She says you're lucky to have a decent IEP, if you're lucky to have a decent one, right? Yeah, and that's part of the initial thing too, right? We went into this whole distance learning, stay safe at home kind of plan, 6 weeks ago or so. And parents are noticing, one, I think, to me, I try to look at what the silver lining could be. To me, the silver lining can be that many parents are going to have the opportunity to understand their child more as a learner and what works best, what time of day to work on what kind of subject, or, if they sit on the couch with a clipboard and their paper, do they do better than sitting at their desk in their bedroom? Just little things that they're going to notice about their child as a learner. Those rich things they're going to be able to share with their staff. I think the other thing is parents are seeing the curriculum that's being sent home and whether or not it's appropriate for their child. So they're finally seeing, oh, this is what they're talking about when they do this. So it's really going to help parents, I think, be more, equal partners at the AEP team, because they're going to have more knowledge about this educational part, right? And one of the things that I've been doing that I suggest parents do is to kind of check out other resources. So I'm a big fan of going to your State Department of Education's website, looking for webinars that they do for, their special ed directors in the state. You can learn a lot about what their position is, what their values are, what they're recommending to directors. I also like to listen in, participate in national organizations' webinars for administrators, state-led directors. And one of the things that I've been hearing recently is some language that's lifted from Endrew F, but it's changed a little bit. And so I wanted to ask you, Jack, about that. And the specific phrase that I'm referring to is in light of the child's unique circumstances. And instead, what I hear from many administrators is in light of the unique circumstances that the district is under now. And so if you can kind of tease out how that's really different, and parents need to realize that.
Yeah, no, I mean, that is a good point, and I hear that as well. And school districts are using that, sort of as a shield or something as far as what they're required to be doing. I mean, it is. I mean, obviously, I think first and foremost is very important to reemphasize that sort of this Endrew F FAPE standard is the standard that's in place, regardless of whether the school doors are open or whether we're distance learning or whatever. And that, I mean, the Betsy DeVos, the Secretary of Education, just on Monday, I think it was Monday, April 27th, did send her letter that was required by the CARES Act to Congress to say there are no waivers, or waivers anyway, with regard to free appropriate public or the requirement of a free appropriate public education under the IDEA. So, all right, that is confirmed, and Congress obviously is not going to do anything, I think, regarding that. So, child at home right now, COVID-19 closure, is entitled to a free appropriate public education under the Endrew F standard, just as they were a month or so ago. But I do think, you look at, progress appropriate in light of the child's circumstances or unique circumstances. I do think, the child's circumstances are going to be different in a, home instruction setting than the circumstances in a 1,000+ or, in a school. And that has to be taken into consideration. And so that's not an out for the school district. Rather, it's a challenge for the school district to determine, all right, what is, I don't know, I have a lot of clients, and granted, I'm sure that I have a certain, type of clients that say want to hire an attorney and whatever. So I don't pretend to speak for the, greater population, but a lot of clients that I've been working with, they are, their kids for the first time are sleeping better. They're less stressed. They're more, they can attend better. I don't know. They're eating better. Anxiety's down, whatever. And parents are not thrilled. Everybody's in sort of a state of crisis, but, and that's a sad commentary really on public education, that they are able to do much better in this home setting. But, that does assume that you have a parent who's also at home. It also assumes that you have a supportive parent and a parent who is capable of, as you were saying, being involved and helping with that instruction and caring about helping with that instruction. Whereas I'm sure, well, I know that there are a lot of other sort of family situations where that's not the case, right? That they don't have that support and they're not getting that support from school districts. But that all plays into, this is the child's circumstances, disability, placement, whatever. And we're probably going to talk about this, a little bit as far as distant learning plans or amendment to IEPs, but it does raise that issue of, after 10 days, we do have a change in placement, right? We don't have our least restrictive environment, if you will, by state order, really is in the home. And that's a different sort of ball of wax than at school. And maybe some of the goals and objectives, socialization or, whatever that may be relevant in a school building might not be relevant or make any sense in a home school situation. And so those have to be addressed.
Right. And Lucy said, yes, that she agrees that she loves seeing the curriculum. And Jennifer is here from Texas. And she said, I've learned so much about my kids and how they learn. So yeah, it's like that to me is going to be the positive. And then what I'm hoping is when parents and school teams get back together face to face in the fall, that we can look at what was successful during this schooling at home and how could we maybe replicate some of that at school.
Right.
And so those are the gems that I'm hoping that parents will be collecting and kind of thinking about. And Anita is here from Virginia. Anita's a trailblazer in our trailblazer group with Jennifer. She says, my concern is my student's temporary learning plan does not document any data collection, only goals and services are listed. Doesn't a plan need an explanation of how and when goal progress will be documented or collected? I'm not comfortable signing the temporary plan without that. So what advice do you give? I think that's the thing. We're seeing so many different models of what a distance learning plan looks like. But what advice would you give as far as suggestions for, is there going to be some documentation and some data collected, throughout the rest of these weeks that, we're here at home?
Yeah. And I think that question really, touched on one of the more difficult, important issues that we're all dealing with. I know in Colorado and many other states that I'm dealing with, they specifically say they don't require a distant learning plan, right? And some school districts are doing it, some aren't, but you have this, or not only distant learning plan, but don't require and don't even advise having an amendment to the IEP, right? And so that does conjure up this notion of, well, it's just this ad hoc thing. It's a distant learning plan, and then the parent says, well, how are we going to measure progress here? How are we going to take data? Who's taking data? And if you're requiring me to take data, how do I do it? And whatever. And the school district could come back and say, well, we're not including that. And so, I mean, that is an issue. And so then my sort of response to that would be, well, this distant learning plan is not a substitute, or even an amendment to the IEP is not a substitute to the IEP. And the IEP, again, is that plan to provide a FAPE, and that the school district is still bound to ensure adequate progress or appropriate progress under that IEP. And so this distant learning plan could be great, could say, all right, here, yes, we want to be on the same page as what we're doing, but that is not a substitute for the IEP. And along those lines, signing a distant learning plan, I mean, one, in Colorado, most states, well, there would be no requirement that I know of to actually sign that. And I'd be very cautious. Well, I'd caution anybody not to sign it or to indicate, yes, I agree that this is in substitution of the IEP. Yes, I want to have a plan. I want us to be on the same page as to what we're working on, hours, whatever that is. But by us getting on the same page and having this in writing, I am not waiving my child's right to a FAPE that is documented in this IEP. So, and that's one thing. And two, I think that data piece is very difficult. I mean, I do, I've advised my clients to the best of their ability to write down, where their child was best they can again, sort of develop that baseline, because all of this happened very quickly. And so we didn't have, these batteries of assessments or whatever to say, all right, March 4th or March 16th, this is where we're at on these skill levels, but to the best a parent can with the help of the school staff, that'd be great. But here's where they're at. And obviously here's the projected progress, but to have that written down and be mindful of that. And to the extent you can take data, or, to me, what I've advised as well is, for a parent, I know they have a lot on their plate, but to journal just briefly, to say, all right, here, 8:30 to 9, Zoom something or other, this is what we did, so they have an idea as to here are the services that were provided. Here's how long they took. This is what they did type thing, not super long narrative, but have an idea as to, because a lot of this building up to, say, next fall, knock on wood, that the schools open again, right? And the parents at that time can address this notion of compensatory educational services.
Right. And one of the things I was thinking about, it might have been kind of good timing how schools closed in March, because a lot of schools had written their third quarter progress reports or their trimester progress reports. So I'm, asking parents, make sure you have a copy of that. What did it say? That would be excellent, baseline of when school closed, this is where my child was at. Of course, that's assuming that your progress report tells you good information, besides more than he's progressing. But yeah, so I think that there's got to be a way that we can, easily collect some things. And I know, a couple shows ago, we were talking about data collection, and I was saying, if you have a cell phone, you can do data collection. You can do a video of your child filling out his math worksheet or whatever. And that's great information and documentation that you can share, or jotting notes down in your phone when you think of something. It doesn't
not only the positive, but the negative, or the problem areas too, the meltdowns or the
right.
Here's what, here's a snapshot of what's going on here.
Right. And yesterday I was in a virtual IEP meeting, and it was amazing how fast they skimmed completely over talking about the distance learning plan. It was like, no, we got to go back here and talk about this. But it was, I thought it's reasonable for parents to say, on my child's IEP, it says every other week there's going to be a probe about, how many sight words he knows or math computation. How can we look at, doing progress monitoring while, the child is at home? And they, the school team was creative with coming up different ways that they could do that. We also talked about parent training, so the parent understands, she had this tub of all these supplies and materials that came home. And it's like, I don't know what I'm supposed to do with all this stuff, So it's like, now the district is like, oh, we could do a videotape of the teacher showing you how she uses this. It's like, great. So you need to have that conversation and ask. And teachers are creative. They can come up with some good ways, but if we don't give them that feedback, this is where we're having problems. What can we do? They won't know that. And I wanted to, let's see, we'll bring up another question here. This is Karen. She lives in Colorado. She said, my son is having a really hard time doing teletherapy with his school therapist. We're waiting to see what the school district will be doing for summer school, but we'll focus on what we can do on our own if it's more of the same. I'm hoping they won't decide he's no longer entitled to anything.
So to me, there's a couple pieces in there. One, and I think that, I don't know what the teletherapy entails, but say social emotional issues or mental health issues or behavioral issues or whatever, those can be very challenging. I've heard some success stories with regard to teletherapy, but as that question clearly indicates, it doesn't work for everybody. And And again, it goes back to, trying to document as best you can as to, again, that progress or that lack of progress, and putting that in this basket of compensatory educational services, whether that's over the summer or in the fall, as far as making up that, those mental health services. But that is it's a very difficult thing. And I, comment too, and please take everything that I'm saying very, very general, because I don't know anybody's particular circumstances, but I do think it's important, just because this service is provided, say, hey, look, we're doing teletherapy. This is going to account for whatever in the IEP, and it just doesn't work. One, I would not force, child to do that if they're trying to fit the child in a box, and it's counterproductive, or the cost is outweighs the benefit type thing. And that rejecting that is not letting them off the hook for, I don't know, somehow compensating for that later on, how that looks. And these are all challenging times, right? To say, well, if I reject, I don't know, is there a substitute, or is there something else that we can do other than this canned teletherapy that you're just saying, here, we're going to log on for 30 minutes, and this is what we're going to do. A comment that I wanted to share too, sort of along those lines, that I have heard from other parents is, I'll just throw this out there, is that, some really good, I mean, there can be good and can be not so good, but, whether it's speech language services, mental health services, I don't know, you name it, that, certain professionals, whether it's within your school district or outside the school district, in your state, outside your state, that they're, doing recordings, or they're doing, they have videos or whatever that apply not only to children on their caseload, but they could be provided or just accessed, by anybody, not in substitution of anything other than, hey, look, we are developing these great resources out there that a parent can access, or at least a school district, school staff can connect a parent with, almost like a library, to say, look, check this out here, doing art or whatever, occupational therapy, or I don't know, various things that now are being brought online. But then I don't know, just like with anything, right? You have this pushback from, nope, speech language time. This is what I'm going to do. You're going to sit down from 10:45 to 11:15. This is what we're going to do. I don't know. It does take flexibility and thinking outside the box. So.
Yeah, because like you said, I mean, you've got to tailor it to what is going to work with your child, and teletherapy won't work with every child, right? So they need to come up with a substitute from that. And I also, to me, like, one of the big things too is that that ongoing communication between parents and staff while school is, still, the school year is still going. And so I wanted to offer a resource for people. I have a booklet that I've written about, effective emails and how you can be objective and make specific requests and everything. So if you'd like to get that ebook, you can just type in the phrase "be heard" in the chat box there. And I'm going to be updating it with specific examples of, like, how could you write an email when you have concerns about the distant learning plan, or when you have questions about when are we going to discuss ESY. So I'm going to be giving you some specific examples of emails that you can tweak. So just type in the comments "be heard." And speaking of comments, let's go back, because we've got some great questions. So I think we'll try to go through these. Let me see. Keisha says, should we have distance IEPs, or wait until we know more about what the next school year will look like, so we know what to ask for?
Yeah, I think that, I mean, my mind sort of goes back to what we were discussing before. I mean, I don't know. I have been advocating for distant learning plans, and one school district like the Denver Public Schools, you know, I understand have been really good about trying to develop plans for or distant learning plans, whereas other school districts aren't doing it at all. Um, and I think that it engages, the parent. It brings people together to at least problem solve. My biggest caution is that that is not a replacement. It's not a substitution for the IEP, and it's not, you know, have to make clear that it's not to be used as a shield in the fall or summer, whenever, to say, well, look, as far as compensatory educational services goes, say, look, we agreed to this in March or April, and we did it, and whatever. But I do feel like my clients feel more in control of things, or more comfortable when they have agreement as to this is what this is going to look like, this is what you're going to provide, when you're going to provide it. So it's not just, I don't know, a lot of parents, I think, feel like, oh, now it's all on them, right? And then the school will sort of show up whenever it shows up, or they'll get a packet in the mail or in an email or something like that. And they're like, all right, well, what am I supposed to do with this? I mean, how, am I supposed to work on this for 15 minutes, a half an hour? I don't know, feel like that they're left floundering out there, as opposed to having an agreement of what's going to happen.
Right, right. And Rick, hey, Rick, he says, would you be kind enough to discuss what enforcement of IDEA might look like going forward? And the change at OCR for the Department of Ed's reduced focus on enforcement over the last 3 years.
So my approach, really, from a legal standpoint, from an enforcement standpoint, hasn't really changed. I think the DOE, the Department of Education, has made it clear, and in Colorado anyway, they've made it clear that the timelines haven't changed, or the requirements. I mean, they're giving some flexibility, and certain parents and school districts can extend timelines. But my approach to enforcement is the same. Sort of the caveat to that is I always remain mindful of what I am fighting for. Why am I taking this legal action? What specifically am I trying to enforce? What am I fighting for? And is this the best avenue to get there? I always think about that, regardless of today or a few months ago. But I'm a little more mindful, or trying to project, is this enforcement effort going to help my client further their goal, or could it potentially be harmful not only to my client but to other clients as well? Because I don't know, in Colorado, maybe these Western states, and maybe it's across the country, I'm not sure, that even though it's clear that the requirement of FAPE has not been waived, there's enough uncertainty that I'm concerned that if push comes to shove, the Colorado Department of Education or Department of Education could give the school district a pass on certain things, or say, hey, look, you need to be more flexible, and I get shot down. But then, the school district or whoever, can use that as, broadening that notion of flexibility, if that makes sense. And
Right.
then, on the OCR part, I mean, what I've heard, like for the last 3 years, OCR is not my go-to for many reasons. But what I've heard is really they're still sort of enforcing or investigating and, really seriously dealing with individual complaints, but they sort of put systemic sort of issues on the back burner.
I know. And yeah. And I, like you had mentioned with Monday, with, the Secretary of Education saying that he wasn't going to request any additional waivers from Congress. That was like a huge sigh of relief. But like all of this, it's still gonna be so much in flux. And the guidance that we get, the first guidance that we get sometimes is gonna change because the conditions have changed. So yeah, we just gotta kind of keep track of that.
But along those lines too, just real quick, is we did get the DOE guidance, but what I read sort of coming out of that, was a pretty intense lobbying effort on the various, like the superintendents groups or the special education directors groups, or but then the disability rights advocates, various that really did highlight the chasm, if you will, that the superintendents or whoever saying, waive all FAPE requirements, let us off the hook. We don't want to be accountable for anything. And really pushing this notion, I guess, of just let us get through this and do whatever we can, and we'll try to clean up the mess later on, as opposed to, and that's kind of scary to me that, as opposed to them, I don't know, buckling down and saying, yeah, here, we have a very vulnerable population here that if we go down this slippery slope, it is going to be a disaster on a number of different levels, and we're not going to be able to clean that up. And so we don't want to be let off the hook. We are going to, what we want is from the DOE, or we want from the Department of Education is more resources, more money, more guidance, not only for our special education population, but, for all students.
Right. And I think, I've heard different, national, administrator and special ed director groups talk about how this is impacting all students, not just students with disabilities, which of course is true, right? But I guess maybe because I don't trust as much as I could, to me, they're kind of setting the stage for, like, calm down. You don't need to talk about comp ed now. You don't need to, concern yourself with that. We're trying, all the kids are, impacted. It almost seems like, and they don't say this, but it almost seems like, therefore, why would your child be able to, be entitled to something extra when all the students are affected with this pandemic,
Right. And that's you raise a good point, and one of the things that I have been thinking about or concerned about, and this kind of goes back to parents being somewhat vigilant about the baseline data, progress, knowing where their kid, was and should be, that type of thing. Because, when we do look at compensatory educational services, say more in the fall, my concern is that because it's going to be such a prevalent issue, sort of systemic issue, that school districts will deal with it in broad brush fashion to say, all right, our general education population has struggled, our special education population has struggled, we've all struggled, and so here's what we're going to do as far as comp ed goes, and I don't know what that would look like, but the concern being that it is going to be so pervasive that school districts, states, or whatever will come up with sort of general comp ed plans or something like that, sort of across the board, as opposed to my child, here's the comp ed services my child needs. And it's not going to necessarily be hour for hour service type thing, but it's going to be uniquely tailored to that child's unique circumstances. Go back to those words.
Right.
Yeah.
And that's, I think, I don't know. I think part of what parents are concerned about too is if they request compensatory services in the fall, and then exactly what will that look like? I know I was talking to an advocate from the Tacoma, Washington area, and she was saying, she doesn't want her son to be pulled more during the day to have more special ed instruction in the special ed room and call that comp ed, when that tips the balance of how much time is he in that least restrictive environment.
Yeah.
So I think, again, we're going to have to be creative because a lot of kids aren't going to be able to stay after school and have additional tutoring, right? I mean, their day is long enough. So I don't know if, parents look at maybe Saturday tutoring or something, but I think it's going to be interesting to see, one, what kinds of, compensatory services are granted, and then actually the logistics of how that's going to play out for kids.
Yeah. In my experience, yeah, I mean, compensatory educational services are difficult in the best of circumstances, right? I mean, here, kids going to school all day, or full plate with after school stuff, sports, who knows what to layer on something else, or what would that look like, especially with, say, behavioral regression or social emotional aggression. What do you do? And yeah, I mean, I think always, parents think outside the box as far as what that looks like. And that raises the point too about evaluations, say in the fall. I know a lot of parents, a lot of my clients anyway, are wary about, I don't know, further evaluations, and that could, I don't know, change in placement or whatever. I'm leery of a school district reevaluating my child, but yeah, I don't know. I can envision some benefit of having some assessment, ideally privately, but whatever, to say, what are we dealing with now, and how are we going to fix this, or how are we going to address this?
And I guess it's going to be interesting too if they don't get consensus at the IEP table about compensatory services and parents decide to pursue due process. And I know some attorneys have said that, the hearing officers are going to probably be pretty empathetic to school districts. And so that's something that I think people are going to have to tread lightly on too, is not to be so aggressive and negative, but to come across. I mean, you've got to be collaborative, right, in order for things to be successful. But that's something else I think people need to be aware of.
No, I agree. And I sort of go back and forth, just on this compensatory educational piece. I know it's leaning more towards, addressing it in the fall when maybe the dust is settled, or there's a clear picture, there's a clear sort of data collection or something to say, this is what this looks like, and this is what I'm fighting for, as opposed to doing it now, but you can see things are not on the right trajectory, or they're not providing this, and therefore you're already tabulating comp ed or whatever. I don't know. I don't have a definitive answer, but I'm leaning towards, hey, look, because I think now in today's environment, that a due process hearing officer, school district, is not, we're still in this moment of crisis, sort of, that we need to work through.
Right. Yeah. And I think ideally that would be, nice, is if we could get agreement for compensatory services to start during the summer. And maybe that would be July, when we have a better chance of having face-to-face, education with kids. But yeah, I don't know if you've heard of Keith Peck and the federal lawsuit that he filed against Hawaii's Department of Education. And he's looking at, we can already decide that FAPE isn't being provided. So let's go ahead and decide that now. And then he's hoping that there can be some parameters set about how comp ed is, decided, and because it's not an hour for hour kind of situation, how do you figure out what is going to be helpful for that student? So yeah, there's going to be a lot of things coming up. I wanted to get to Renee's comment. She's a advocate in the Chicago area, and she says clients are forwarding weekly and daily e-learning assignments to me due to what I call thrown together lesson plans. I'm e-teaching the topic using additional resources. I'm following the IEP, accommodations, modifications, etc. I have situations where the IEP requires more to meet the students' unique needs. I'm teaching as instructed by the teacher and then with my additions. The difference is astonishing. I'm documenting everything in great detail for future purposes. Yeah, and luckily Renee is, an advocate that also has that background in education where she can provide that service to, families. But again, I think the theme is documentation, right? And that, like you said, even if it's just some short entries into your journal or into your phone or whatever, to be able to keep tracking that, I think is going to be helpful. And let me see. The other thing that we wanted to talk about, Jack, while I looked through from our questions was, and I haven't heard this, but I thought it could come up. What if schools say, we're not going to do summer school this year for our typical kids. Therefore, since we're not providing that, we don't have to provide ESY. So could you talk to us a little bit about ESY and what your take is for that for this summer?
Yeah, I mean, my take, I saw that question. I hadn't really thought about that before. I mean, my take is that failure to provide summer school is not sort of equivalent to ESY, or it's not equivalent to school closure, right? I mean, like in Colorado, I think in most states you have compulsory attendance laws and you have compulsory sort of hours of instruction, and that ESY is part and parcel of FAPE for certain students that require that in order to obtain a FAPE or to receive a FAPE, right? And so it's not ESY is not summer school. It is more of a continuation of a child's educational programming, that unless they get that, unless they are able to maintain those skills over breaks, doesn't even have to be summer, it could be, spring break, winter break, whatever it is, we will spend too much time in the fall, obviously trying to make up for that. And it's this, turns out to be the cycle. So long way of saying, I don't believe the school districts saying, hey, look, we're just shutting down for the summer for gen ed students, therefore we don't have to provide ESY. I think that would, that would be violative of the IDEA.
Great. And Laura has a good question. She said, what do you do when the district was supposed to complete evaluations and provide related services prior to COVID-19 and did not? And now they can't reasonably be expected to, and the student was to receive ESY that would literally be worthless in the current environment.
Well, I mean, to me, the evaluation piece is one issue. The provision of related services may be another issue. And then the third would be, the worthlessness of ESY. I think, and maybe they're connected and I'm missing that. But, with regard to the evaluations, I know that that's very, that's a challenge, right? And I know that school districts are required to continue and complete evaluations given their ability to do it in a safe and healthful manner. There are obviously certain reevaluations or initial evaluations that require in-person contact, which can't happen. And again, I think what I've read is that the Department of Education or State Department of Education are giving school districts, flexibility in, if they say we just can't get that done, then all right, well, we can't get that done. Do the best we can, and somehow we're going to have to address that when we can get it done. But that is, completion of evaluations determination of eligibility, right, is becomes an issue. The provision of related services, again, depending on what those are, it does become, all right, can it feasibly be done appropriately, productively? And if not, and it's, it's a no fault to the school districts, it's the fault of the COVID-19 situation, then that to me gets put into that basket of, we're not waiving it, we're not giving it a pass, but we're putting it in that basket of, we have to address this when it's feasible, practical to address it.
Right, right. And Lisa brings up an important point, and I think about this as far as, being white, middle class, privileged, and knowing there are families in homeless shelters. There are families that have parents that have to go to work, and the older brother or sister is in charge of the younger kids. There are so many different situations, and it is very, disheartening to know that there is only so much, I guess. And how can we try to look at serving other people? But here, I'll get off that and right to Lisa's point. She says the only students who likely get comp services will be because their parents knew enough to, one, have to update the IEPs, two, know how to take data, three, know how to ask for it and make a case for it, or have a lawyer.
I agree. That is a sad, accurate point, and I think it too is, I don't, and I don't know, other than your show and other shows or webinars, is, getting that message out, because I do think that, intentionally, unintentionally, whatever. I think that there are school districts, school staff, just, I think I mentioned to you a situation in, say, Nebraska, to say, look, we're closed, but you're not closed. You're providing, you're saying it's enrichment, but it's not enrichment. You're providing educational opportunities to regular education students. But what parent would know better, or one, and trying to fight that, or saying, what are my rights under COVID-19? And you have a lot of school districts, like the question or comment earlier on about this sort of distant learning plan that didn't add up to the IEP, that maybe a school district wanted the parent to sign off on, to say, hey, look, we're in agreement that this is what we're going to do for this period of time. And so they can use that later on to say, well, you're not entitled to comp ed services because you, in effect, agreed to this earlier on. But we face that, I guess, as advocates, lawyers, parents, whatever, that in the best of times, parents don't know what their what their rights are, and maybe taken advantage of by school staff or whatever, saying this is what we're going to do, take it or leave it. And a lot of times parents maybe don't know any different.
Right. And that is, for me, the purpose of being able to do a weekly show for families, is that this can provide you information, and it can give you some actual things that you can go back and request and know how to phrase things. So again, if you want to type in the comments, be heard, that phrase, and then Tuesday I'll be emailing out some examples of email language that you can use when you want to make certain requests from the district, that I think is really helpful for folks. But we're close to the top of the hour, so I know we have additional questions here that we didn't get to, and I'll try to come back afterwards and comment on them. And so let me see if we have one that would be helpful for us to still answer here. Oh, here's a good question from Linda. She says, what is the expected etiquette for virtual IEPs? District does not want to use raise hand or chat, and won't commit to not muting, and names are displayed. In Florida, they are taking the ESC staff member and designating as a facilitated IEP that both parties don't have to agree to. So my guess is, Jack, you're like the rest of us. You've been to a few virtual IEP meetings the last few weeks. So, and one of the things I had said to parents is I think it's really good to request that people have their camera on, because I like to look at body language and get cues on that. And recently they say, oh, we're not going to use our camera because it slows down the feed and, makes it interrupt the internet service. And it was like, well, there went my suggestion of keeping the video on. But so what kinds of tips do you have for parents with online IEP meetings?
Yeah, so I mean, it's a very good question and a very challenging question, because obviously, those of us say, like you know, who do many IEP meetings, I mean, some are fairly cordial or, collaborative, and then there's others just, they aren't, and they haven't been, and they're not going to be. And it would be nice if, and maybe it's out there, there's some etiquette guidance for virtual IEP meetings, especially for contentious ones. To me, a couple guidelines would be, as you said, I think it's important, helpful to have everybody's video on. I think also that because typically there's going to be a case manager or somebody's facilitating that IEP on behalf of the school district, which is fine, but that person doesn't have the ability to mute everybody. I've been in situations where everybody's on mute. I was part of it. I was on mute, and we're relying upon, say, the special education director to unmute us so we can talk, and that the parent is never forced to be on mute, that they have always the ability. If they want to mute themselves, the dog's barking, child crying, or whatever, they can mute themselves, but they are never muted, which I have been. And I've had clients just go crazy. Of course, it's like, you're stifling me. You are muting me, literally.
Yeah.
And therefore I don't have meaningful access or meaningful participation in this IEP. I mean, I think that those are, important. I think also a pause, whether it's a hand raise or, just like in your show here, I know like on Zoom, whatever you have, chat columns, that periodically there's a pause, and we go, you go through the questions or whatever. I think it's a little cumbersome in my mind, sometimes, because it gets addressed, but I think to have that pause, to at least clear that out and say, all right, here, and then move on.
Right.
Yeah.
Yeah, and I think the nice thing about, most of the platforms that districts are using, like Zoom or Google or Microsoft Teams, the school district has the ability to make a recording of that, and they can record both video and audio or just audio. However, I always still think it's important for parents to make their own recording. And so this free app that I'm like loving is called Otter.ai. And what I do, and I mean, I tell the district, that I'm going to be recording, but so you can just have it up on your computer. You can have it start recording when your meeting starts. The wonderful thing is it's free and it gives you a transcript.
Huh.
So like as it's recording, you can go over to that, site and you can see the sentences rolling by. And so you end up with an audio, but also a free transcript. It's artificial intelligence, so there's some tweaking, that you have to do. And then what's nice is I can send the parent the link, and the parent gets the transcript, but they also get the audio. So like as they're reading the transcript, if there's something they don't remember, they click play the audio starts at that specific spot. You don't have to go back and forth trying to find stuff. So my big tip for the day is use Otter.ai. And
So it's Otter, OTTER.
OTTER.
Okay.
AI. Yeah. And So you get, I think, 600 free minutes. And that usually, will do a parent fine. I went ahead and, I have extra minutes that I've, purchased. But for parents, yeah, that 600 minutes a month is going to be more than enough for what you would need. And so that would be something that I think would be really helpful when you're doing your online meetings. And then also when you start doing your in-person meetings, it also has an app for your phone, so you can record it, get the transcript right on your phone. So it's pretty cool.
Yeah.
But I want to be cognizant of everyone's time. I want to not welcome. Well, we can welcome you back, Jack. We can start over like Groundhog Day. I want to thank you for being here, because people love hearing from, directly from the people that have been involved in different cases. You have had many different cases in the 10th Circuit and now from the Supreme Court that have impacted families. And I know people are so appreciative of the advocacy and the work that you've been doing for families throughout a number of years. I wanted to put up your firm, Spies, Powers, and Robinson Law. So sprlaw.net is the website of the law firm that Jack works with. And Jack, do you have any closing sage advice for us?
No, I was just going to say document, and don't think just because we're in these crazy times that your child's rights are any less enforceable or less meaningful than any other times. But we want to be flexible, we want to be collaborative and cooperative, but vigilant about ensuring that our kids are progressing appropriately.
Right. But thank you so much. Yeah. To all the viewers, and know that this will stay up as a replay. So if you have friends that missed it, they can come back and watch it. Next week is the first week in May, and that's our Q&A time. So next Thursday at noon Mountain Time, we'll be open for any kinds of questions and answers that people want to, supply for other questions that parents have. And I just want to thank the parents that are out there and that are doing the best that they can, and know that you have to keep your mental health and your child's mental health as a priority. And if things aren't going well, I say skip it. Don't do that packet if it's too stressful, right? And so we need to give ourselves permission and some grace to know what is really best for our own kids. So until next Thursday, you guys have a good week, and we shall see you then. Thank you, Jack.
Thank you.